we're just going to do this. I'm going to talk for a minute, very briefly, and then I'm going to read the chats, and then we'll go. This is not going to be a long stream. It was going to be a much longer stream, but first, the release of information that's supposed to be protected at a very specific time, right after I announce a show and right before the show starts, is something that is concerning. And of course, I will have a lawyer looking into that right away.
Things are going to start happening to me now.
You've done all the reading. You're a scholar. You're a professor. You've done all the reading. You've done the intellectual heavy lifting.
More or less, eat shit and die.
You wouldn't know a fact if it begged you all night long.
Want to give the wrong impression because I am very high.
Fucking right up behind him with a hatchet. Smash, smash, smash. Yeah.
Care. I'm a libertarian. What I'm getting is,
did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Welcome everybody to the Libertarian Podcast Review in honor of Juneteenth. We're playing a little Afro Man. A little intro here. Do I condone drug use? Not necessarily. Am I thinking it should be legal? Perhaps. What about with children? That is the one we're going to look at today. Some shocking developments with Nick Rekieta. Look, someone said, Tyler, why don't you finish your sentences? Sometimes I just get distracted, okay? But I think you can get the gist of what I'm saying here if I get distracted and I have to come back to something. Be it as it may, let's take a few things here. Alt-right Kiwi farmers be like, Nick gave his child Coke because of libertarian views. Government could have prevented this if I were a dictator. Okay, we'll talk about that. Eddie Grimm says, and that was by Patrick. Shannon says, I watched his stream and saw the leaked info. No, not fucking cool. He is getting closer and closer to a wood chipper. Yeah. So we're going to... I've got the document here, the leaked document, but I have it redacted, and I'm going to show it up here, the redacted part. And we'll also play... I showed the intro there. This was on 6/7. This hearing took place, and it just got released yesterday, so a week or two after the fact. And he's like, it seems like it's timing. All right. Tyler has ADHD and is cooler for it. Maybe. Lincoln says, good morning, Tyler. I've been loving your coverage of this shit show. Yeah, I was not going to do it. I had a whole nother show planned, but then this leaks out today, and I've got it. It's Juneteenth. And so here I am. By the way, I had papers this morning. Here's the process for filing what's called an ex parte. It's an emergency hearing. The way that we do it, it's different in every county, but the county I was going to go to this morning, you have to notice the other party by 10 a.m. the morning before. So this is going to be for tomorrow. So if it's a holiday or the weekend, it doesn't count. And you do that, and you have to file it by 8:30 that morning. So I was in just Dropbox. So I drove down there. I'm like, got to do this, got to get up a little earlier, drove down there, hadn't noticed the other party. I was going to do it all as I got there, walk up to the door, it is closed, and immediately I'm like, oh my God, it's Juneteenth. How are all these baby mamas now going to be able to go and have their deadbeat dad, and how is little, and prosecuted now today, or, in DCSS court, how is little Chauncey going to get his support that he's never actually going to get? Jokes, people. Okay. But my point is, I'm a family law attorney. In case there's a bunch of new people that have come in there and they've seen these streams, get a lot of hate, a lot of love. I'm trying to take things from a little bit of a different perspective here, and this one does happen to line up quite nicely, the one today, because like I said, I do family law. Now, with that, there's child protective services, juvenile dependency, and those situations. They're a little bit different. For us, they're in the same courthouse, but they're just a little bit different, and they often overlap. Let's say you have a case with CPS, Child Protective Services, and they want to take it up through juvenile court, or there's a dependency hearing. Oftentimes, it's a situation, you have... those usually go through family court if it's adversarial. Let's say it's a family, like you have here with Nick Rekieta, and CPS has stepped in. Now that doesn't go through the family court, it goes through child dependency, welfare, juvenile court in a sense. It can, and they deal with foster placements. They deal with immediate emergency issues, and I've had them in those courts where mother with children, and she's not doing much to protect them. She's claiming that father is abusing them, and she's filed restraining orders against him or contacted the police, and CPS is coming in and saying, okay, but you're not moving out of the house. At some point, you're going to have to do something. So they bring a case, and they're basically like, we're going to take the kids away from you. And then I got involved, and we basically had to take it from filing divorce and custody paperwork to make sure that they're just showing that she's serious about protecting her kids. One of the first cases I got involved in, and it really helped jumpstart my family law stuff when I started solo, is a lady. She's a CPS attorney exclusively. And I mean, that's kind of even part of her title. And she contacted me because it turned out, started a CPS case. The shit show got much bigger. It was exploding out, and we had a long, it was like 6-7 day trial, which is pretty long for family law stuff. You just didn't go there. It was all on custody. And the word anal rape was used so much. It was crazy. Maybe someday we'll get into that. It's been a long time, and things worked out fine. But it was also so crazy. Now we're going to talk about this a little bit. So I just got back from vacation. Is it a vacation? I'm now in the office. I'm going to be doing this solidly. There's drama with Tower Gang. Behind the scenes, it's crazier than you would expect. We'll see how that pans out. Tune in tonight, 6:11 p.m. Pacific, 9:11 p.m. Eastern. We'll see how that goes. With me, my son graduated college. I had a show to do on that, which is you got these, nice private college, Christian college, and it's inundated with DEI shit. It's inundated with COVID. What I mean by COVID, it's like they always have to refer back to, 4 years ago, and we were all forced to shut down. You kids are so brave for making it. I'm like, you create a Holocaust, the school shutting down. And then you talk about how you're such a Holocaust survivor. Holocaust is a little bit, over the top here. I get it. I'm just saying you caused a problem, and then you say how the kids are, overcome this, and the whole school is. It's like, yeah, fuck you. And it was really annoying. But my son graduated. He was president of a nursing school, so he got acknowledged right away. It was one of the first, and then we could just go hang out and eat donuts and drink coffee. Okay. That was one clip I just played of, Lincoln says here, has anal rape been more of a factor in the TG fallout or in the case he mentioned? So good. I did, by the way, I talked about it a little bit when I first interviewed Cole, Toad, and I think Jose on my show way back, probably the first 20 or so episodes. They came on there, and I referenced this case in a little bit more detail if you want to go talk about it. The gist of it is, I don't even know. I'm not going to get into it right now. But it was more prevalent in that case, Lincoln. Thanks for the the solid inquiry. Let's see. We're getting some people showing up here. I appreciate that. Okay, so let's take a look. First, I want to look at the actual, because Nick started live streaming, and I did not. I can't watch it all, and I don't intend to. Okay, but he's made some comments, and I think it would be helpful to walk through this. So some of it I think was partially what we had played earlier there, the first opening clip, but let's go to this one and we'll just walk our way through these. They're only like 2 minutes or so, and so it should be good. Let's make sure that's going on here. All right, ready to go.
And when you do take a moment, and you work with government, and you can find this in the recently leaked documents, and you cooperate by, say, asking them to come into your home, they will lie under oath to the judge. That's right, Alicia Sweep.
Okay, first of all, he's correct. I've broken down, there was a case here that went up to 9th District about CPS lying and about the children. It was outrageous, and they were trying to use they being CPS workers, were trying to use qualified immunity to justify their actions, and is lying something that can be done there. It was fascinating. The 3-judge panel just ripped them apart. I believe it went against them. It had gone against them. So yes, CPS, Child Protective Services, whatnot, can definitely have issues and of people lying. That's with anything. Okay, I've been in court, and it is always frustrating to have police officers as either not. Usually they're not my clients for some reason. But as far as even the opposing party or firefighters, what they will do sometimes they try. Oh, I just came from work and have my uniform on. Okay, and then it's a bias with the court, but they'll lie just like anybody else. Maybe even more so. So I get that, and that's in their own cases. Or I've had it, when you're in, and you just know that they're lying. And it happens. I get it. They're just like anybody else. They're not special. That uniform is not a unicorn. I get it. And and we'll walk through the findings of facts, conclusions, in order following a joint emergency protective care hearing and admit-deny hearing. Okay, that's the one Nick is talking about here. But are they all lying about this? Here's where the body cam footage, I think, is going to be important. Now, did Nick actually invite them into his house? I don't believe he did. Matter of fact, he told them, get the warrant. They had a warrant, and then let me have the code. And he said, I'm not going to give you the code. And so they had to break down the house. I don't know that there was any invitation going on. I say this, and I will reiterate it over and over and over. It is always CPS can save a family, and they can destroy a family. So I'm up in the air. I don't know which one we're going to get. I just had a case with a guy. It's a client I've had for years, and the opposing party is just a piece of crap mom, and she keeps filing and CPS saying, oh, child's injured or whatnot. He got a great CPS social worker. It's a dude. This guy's, not your liberal out here, and he was great for my client, and my client is good. So that's obviously helpful as well. Okay, let's go to a little bit. Tyler, is his lawyer a family lawyer? Have you seen anything suggesting a possible divorce? I don't think I haven't seen anything about a possible divorce. It doesn't appear to me to be that's the case. I don't believe his attorney is a family law attorney, mostly because it's the criminal. This is what I would do in this case, and I tell people this all the time. They're like, "Hey, I've got this CPS," or they're on my side, and all of a sudden it turns into CPS issues, and they've got that. I send them specifically to a CPS attorney to work that issue. There's a lot of interworkings there that are necessary to do. And so for him, I would not use. Now, it's a little town. I get it. So maybe there's a lot of people like Nick who do everything. I'm not a fan of that kind of stuff. You can be bad at everything or good at one thing. And I prefer good at one thing. And especially in this case, I would get a CPS attorney that does CPS defense and be the attorney for this part and your children. And then I would have your criminal defense attorney doing the other side, and I would have them work together as necessary. Nick needs to plead this one. There's no victory to be had here. Possibly. We will. What about Trump? I don't know. What about him? He acts like the legal trial he's in is the only thing his audience would care about. I hope he goes free. However, he can't pretend he wasn't doing drugs on kids and getting affected. We were going to. Good point. I'm completely in it, except for new details that are coming out. Let's continue this though.
They will lie under oath.
Correct.
To the judge.
Correct.
They will fabricate.
So will you.
A situation that did not occur.
Okay.
They will lie about your willingness to cooperate.
And I just want to make that point there, which is that should not be an issue. Oftentimes, clients are like, do you need to be here? If CPS is coming over, quite likely. That's probably okay. Kind of depends on the situation. Like I said, it could be a crapshoot. But you should not be held. It's like the Fifth Amendment, your ability to remain silent. You have that right to get an attorney. A lot of people look, if you listen to the crime podcast, which I've listened to a ton with my travels lately with my wife. Yes. Do you get an attorney? Do they look more suspiciously at you at times if you do get an attorney right away or you clam up? Certainly. But that can often save you. I've seen way too many times where Nick himself here is making comments. And by the way, he just mentioned, and this is what the kind of thing where I held my head. He mentioned here Alicia Sweep, and he pointed at the camera, or he motioned to the camera. She is the Kandiyohi County Health and Human Services. I don't know. She's part of that. So I think she was the one that did the welfare check with the police at the time. So he's calling her out. You got to stop that, Nick. You got to stop calling people out specifically. And if there's this kind of conspiracy theory going on, then you've just made it worse. Okay, deal with it as you need to, but have your attorney talk about it, not you. And by the way, there's the importance of having an attorney. There's oftentimes you need to really stand up for your client, and it's much better that it's coming from an asshole attorney to the judge or the jury, which I don't deal with. I do bench trials. It's much better coming from you than making your client look like a piece of crap. Okay, I've had to do that. I've stood up. I've gotten where I told the judge he was being hyperbolic and it was a ridiculous comment and he lit me up, but it needed to be done to defend my client. And then, we kind of went our separate ways because I'd kind of lit myself up in front of this judge, but it was necessary, but it wasn't my client doing it. The guy is mad at me now, not my client. I mean, perhaps, but it didn't affect that part any further. He didn't get, but Nick is putting himself as the person, which means he's just unstable. Okay.
They will lie about things that you said. They will generate statements said by other people out of nothing because I was there and that wasn't said.
Okay. Body cam footage was there too. That's gonna. And I'm sorry to keep. This is taking forever to get through it. 1 minute 27 second clip, but the body cam footage will save or bury him. So what he's coming out here and saying, it's going to either save him or bury him, and we will see about that.
It will violate the rules of evidence.
Okay.
They will violate the rules of civil procedure. They will violate the rules of juvenile.
Well, first of all, we're not. The cops aren't held to any of that. So I don't know. We're there on civil procedure. What's the rule of civil procedure you've violated?
Procedure. And disinterested judges and very fucking terrible attorneys.
Oh, now he's talking about himself.
Will let it all go. Because everyone grovels at the feet of government.
Okay, he's not completely wrong on that, and I want to emphasize that. That's the Barnes position in a sense, but I think Barnes is going to be shown to be highly, irrelevant at some point, and that was kind of my issue of taking him on before. Okay, here we go. We're going to play this one. This one's a 3-minute clip. It's a little bit more, and this one, we'll try to get through it. Sorry, but I've got to make comments because it's necessary to do so. Josh says, yo, what's good, Tyler? Just living Juneteenth. The more this guy talks, the more I want to see him 6 feet under. We will see. There could be a time in what I do today, you're all in agreement of the 6 foot under. Let me speed this up a little bit just to help us all. There we go.
Stream, it was going to be a much longer stream, but first the release of information that's supposed to be protected at a very specific time, right after I announce the show and right before the show starts, is something that is concerning. And of course, I will have a lawyer looking into that right away. I know people want to draw conclusions from whatever's going on. And look, there's no way around it. There's nothing to say other than people will get to draw their conclusions from what they read. I'm not here to fight you guys at all.
By the way, I just mentioned here, so what we're going to walk through this document, okay? And he's not necessarily, he kind of, there's some people that are saying, oh my God, he's admitting everything in there is true. Well, that's not really the case. He is BSing with stuff here. But I think what is true is this is a legitimate document. The Kiwi Farms, I think, have verified that they believe it is. It looks very much right to me. You got to know what you're doing to make these up. But he's not saying, no, that document has been leaked is not correct as far as that's a fake document. So I think he's admitting that this document is correct, which is disturbing, and we went to that.
I'm not here to fight your conclusions. I'm not here to fight or justify or prove anything. I don't need to do that for you. Believe it or not, a lot of really well-meaning friends want me to do that. And these people are lawyers, which is shocking. They want me. I'll say it this way. They say, Nick, you need to do X, Y, and Z because of your YouTube channel and your online image. And my response is, sir, madam, I don't know if you know this, but the lowest priority in my life right now is my public image for the purposes of YouTube. And
okay, then why are you doing a stream right now? Okay, I've had big things in my life, and the last thing I would be doing is talking about them on a stream. So I don't think that's actually true, or you just don't know how to deal with your whatever. I don't know what these people, what the advice is giving you, but I think when you continually go back to streaming, and that's your goal to get back there. And by the way, we'll talk about it. You don't have possession of your kids yet. How about that? This does seem a little bit out of sorts. That's just my personal opinion.
So any of you who want me to come out here and like do some weird grandiose apology or prostrate myself in front of you, let me just help you with my public image right now. Fuck you.
Yeah, I don't care about his public image. Once again, this is more of a legal thing that I'm looking at, and kind of a guy that's spiraled out of control, one that is very angry and calls out other people. So then it just leads to this. And part of it too is the Barnes Viva Fry ridiculousness that they've tried to put themselves into by calling other people names and whatnot. And so I want to give you a little perspective on this, and then also from a libertarian point of view, where I don't think I'm ridiculous. I'm not like Nick. I'm not blaming the government. The government's out there. Now you have to navigate your waters that are put before you, no matter what kind of society you actually want or what you think rules should be. These are the rules in place. How are we going to get those, and how are we going to get through them and whatnot? So let's go on.
Right in your goddamn mouth. I'm not here to worry about what you think about me. And that should be obvious to damn near anybody. And if you think it's in my character to come out and grovel before you and say, oh, I'm so sorry I let you down. I didn't let you down.
True.
I didn't pick you up. I didn't make you, and I didn't make promises to you.
You did make
your kids. If you feel
though.
let down by me, let yourself down from the stool, Robin Williams.
Ooh.
I'm not here for you.
Okay.
I'm not here to own your feelings. And I'm not here to apologize to your feelings and sensibilities either. And if I did, you shouldn't respect me. Because anybody who comes out like a little fucking bitch and says, I really am worried about my public image, not my family, not my liberty, not holding government accountable, none of that. But my public image, my public image? Well, you're probably a fat Canadian. Or maybe a skinny Canadian who can't fly to the right city. Or maybe you're a doughy Minnesotan. I don't know who you are. But I'm not here to apologize to you or for anything.
There you go. And so I don't know. I don't know what we have to do with this. Suicide joke. I'm not sure FU is a convincing argument. Right. He did not consider if it might be a bad look to have pictures of drug addicts and deranged criminal in his background. I would. By the way, I was just thinking that I would never. I'm not a fan of that. I have some posters up, kind of similar painting ones up here in my office, but they're bikes. And probably, you know what? I'm looking at one. It does look like it might be Leonardo Pipoli, who was taking Sarah, which is like this manufactured type of EPO. So I have some. Maybe I need to take that one down. Barnes and Viva. It was a thorough homestayed module on cocaine. Yeah. Okay. This doesn't seem a good venue to make jokes, Nick. It does not at all. So let's move on from Nick. And by the way, those are just clips that people put online. I'm not searching out his. I don't want to watch a show. I don't want to make time. I will take clips totally out of context and post it and talk about them as much. Nick's got some points here. I don't think he should be apologizing. I just think he should not be online. But thank God he is, so that we can do a stream and grift as much as possible. And yeah, so it's a little depressing. Okay, I'm confused. Says Tabby Timeout. Is Nick trying to get convicted? Yes, he is. Okay, so let's take a look here now. And I have, let's say, window. I think this is the one. It's not the greatest quality, but this is what happens with leaked documents. But I did take the time to redact it as best I can. If there's parts in here that are not redacted, I apologize. I mean, I don't think that's going to be the case. Let me just see if I can. No, I want to go there. Single page view. Okay, there we go. Okay, so this is findings. This was June. I don't know if you can see it. June 7th, 2024. The matter of welfare of the children of Kayla Rekieta and Nicholas Rekieta, parents. Findings of fact, conclusions of law and order, following a joint emergency protective care hearing and admit deny hearing. Okay, make sure I didn't get any more of this thing. Epic rise and fall. It's depressing. Hopefully details of this are wrong somehow. That's Tabby. Thank you for that. So let's take a look exactly what you're saying here. I do agree. And that's been my point from the start, is talking about the kids. Everyone's like, oh, but Nick was nice to me, and so I'm going to defend. Fuck him, man. I say this over and over. Go back and watch the streams, which are at some point I think to begin with, you bifurcate this. You're concerned for the children and Nick. I don't have any concern for Nick. And yes, it would be nice to get him back, where these kids aren't ruined, because you don't want to have kids ruined. I see it all too much. Next thing you know, they propagate the same situation. So if you're going to be like a conservative Christian type, when you're worried about culture, you are worried about how these kids are influenced in this. Got it. But they're not completely lost. So I only am concerned about that, the kids necessarily, because the parents may not get their shit together. You're seeing what he's doing here. He's not getting his shit together very well. So it may not ever come about. And if that's the case, okay, we just keep moving on and doing our thing. Okay, let's talk about this here. So here we go. I'm going to read through it. 11 pages here. The above title undersigned judge of the district court, and I'm going to stop and make, this is me not finishing sentences, I'm going to stop and make comments as necessary or concerned of what I know. County Courthouse, Wilmer, Minnesota. Present at the hearing were the following: Kristen Pierce, Assistant Candio Yohe County Attorney; Rachel Molesbury, Assistant County Attorney; Alicia Sweep, that's the one that he yelled at on there; County Health and Human Services; Dan Weber, Attorney at Law with, so that's Don Weber, that's Nick's attorney; John Mueller, that's attorney for Kayla, she has her own representation, good for her; Carter Greiner, Attorney at Law for, and there's 3 children, okay, which I've redacted, you're welcome; and Christy Barber, Guardian at Lidum, okay. That's somewhat important now. He has 5 kids. There's only 1, 2, 3, 4. Oh, Guardian at Lidum might be for the other 2, I think. And they'll talk about here this McKenna Law Advisory, which are for kids over 10. They have an option of having an attorney, and so I think that's what the attorney at law did for them there. And then the Guardian ad litem was just a court-appointed, probably attorney for the 2 that are under 10. Foster parents also appeared. Foster parents, that's hard to see. Parties and participants appeared in court. At the beginning of the joint emergency protective care hearing and admit and deny hearing, the court met the requirements for the hearing procedure outlined in Minnesota R Juvenile Protection Procedures 46.03. And I'm by the way, I don't practice in Minnesota, so I'm not, for the most part, not looking these up. It's probably similar to a lot of stuff that would happen in my case, or my state. Okay, and so if you can't read this all here, above and upon the petition herein for the testimony of participants, the following. Findings of fact. Subject matter. The children are subject of the petition are, and it gives them, and I redacted their birth dates, but I left their year so you could get an idea. 2007, a male, that's the oldest. Next is a male, 2011, female, 2012, female, 2015, and female, 2017. Okay, venue is proper in this county as the children reside there. Parentage, so you've got to establish some things that this court even has the ability, their reach to come there and make it. One, it's a venue is proper because they live here. Okay. Kayla Rekieta is the mother of the minor children. Nick Rekieta is the father of the minor children. Mrs. and Mr. Rekieta are married, and they share joint legal and physical custody of the children. Therefore, there are the parents. Petition, a CHIPS petition, which is their version of Child Protective Services, was filed on May 24. The alleged statutory grounds listed in the petition are incorporated herein by reference. Prima facie finding child protective matter. Now, prima facie just means like on the face, it is a matter of course, and that there is a protective matter. The court previously found that the petition established as a prima facie showing that a juvenile protection matter exists and the children are subject of that matter. Prima facie finding regarding endangerment. The court previously found that the petition establishes a prima facie showing that the children's health, safety, and welfare would be immediately endangered if the children were released to the care of the parents. And it's such things like we don't have to prove much other than they were doing drugs or there were drugs in and around the children. If that's the case, it's just a de facto, it's a problem. Now we're going to have this case. Something else would be like, oh, you're driving recklessly, and that's not necessarily an endangerment of the kids, depend on what those circumstances are. That would be something that would not be prima facie to conclude that. Okay. Service, Mr. and Mrs. Rekieta with the summons. Petition May 28. Motion to intervene. No motions to intervene were made. And that's just basically an interpleader, I believe. Another party coming in, maybe a petition by some of the other family members that might want to come in and make a plea that they should be the parents or something like that. I imagine that's what it is. ICWA, that's the Protection of the Indian Welfare Act, does not apply. That's if there's any kind of Indian blood. Now you've got to go through a whole separate set of laws, basically under the Indian Child Welfare Act, the ICWA, and with that, the tribe would then be involved. That's not a factor. Just letting you know, that's a step we always have to check box to make sure it's not an issue in family law. McKenna's Law. The court provided McKenna's Law advisory to 3 kids. 3 kids, which are, I think, the ones over 10. That's the McKenna's Law in Minnesota that basically said if there's kids under a protective issue or juvenile dependency, they give the right, they have an option of having an attorney for themselves, and one will be appointed. It appears that 3 of them did take that. They're over 10. The other 2 are under, and they have a guardian ad litem, which is basically like the minors' counsel. Same idea. It's just that I don't know what the difference is there, honestly, because they're both going to be appointed by the court. Actually, that one might be that they have the option of having their own attorney rather than the one appointed to them, and I think that's what it is. The parents were previously advised of the right to be represented by counsel on the record and required by Rule 36, and the parents were each represented by an attorney at this hearing. Ex parte hold and order for hearing. The children were placed on law enforcement hold. The date of removal is May 23, 2024. The facts that warranted removal of the children from the caregiver on an ex parte emergency basis are as followed. May 23, 2024, law enforcement officer in the Kandiyohi County Sheriff's Office executed a search warrant at the family's residence. We talked about that one before. During the search, narcotics and drug paraphernalia were located, and the parents were placed under arrest, and the law enforcement officers placed the children on law enforcement hold. Continued EPC hearing. An emergency protective care EPC hearing was scheduled to be held on imagine it says May, it says MA 28, 2024. At the time, the parents motioned to continue the hearing for good cause. The court found good cause to continue the EPC hearing to protect the rights of the party. Just moving the case to another date, more, till June 7th, I believe you had here, and perfectly fine. It doesn't mean that they get their kids. The kids were removed. It just means like if you're fine with this and kind of still not having the kids at this point, we'll move it on here. But you have this right for a timely hearing. The court received testimony from Alicia Sweet, Christy Barber, and Robert Rekieta. All witnesses were placed under oath to providing testimony. Imagine Robert Rekieta is like his dad or his brother or something like that. Christy Barber, I think, was one of the guardian ad litem. Alicia Sweet was the county, I don't know, the social worker that went in there. By the way, you have minors counsel or guardian ad litem, and they have recommendations for the court. They are almost always going to win the day. So you've got to basically, because they're talking to the kids and they're doing what they think is in the quote best interest of the children. Exhibits, 2 drug test exhibits. Exhibit 1, drug testing of the parents. Exhibit 2, drug testing of the children. That is the shocking detail in this thing. Protective care determination. All parties and participants were offered the opportunity to cross-examine petitioner regarding the ex parte filings. After receiving additional facts, the court determined that protective care shall continue. The court makes the following explicit and individual findings in support of continued placement. KCHHS received a report involving Mr. Rekieta and Mrs. Rekieta on May 23. The report was that law enforcement were going to the home of Mr. Rekieta and Mrs. Rekieta to execute a search warrant. Upon executing the search warrant, the law enforcement officers found over 26 grams of cocaine, ketamine, drug paraphernalia, firearms, and ammunition in the home. We've talked about that. Miss Sweet went to the family home while the search was ongoing. At the time, she learned that the home was very cluttered. It was difficult to walk around the home without stepping on. This is like a 5,000 square foot home without stepping on clothing, bedding, or blankets. Kid 1, 2, 3, and 4 were present at the home when Miss Sweep arrived. Kid 5 was not. Okay. After being placed out of the home, the children were subject to hair follicle drug testing. And we'll talk about that in a second here. All the children except blank tested negative. Blank, this is a 9-year-old child, tested positive for cocaine at a level over 5,000 with a cutoff of 500. I think maybe we need to stop here, maybe take a look. Let's just go back to some of these things. Okay. Okay, you guys are talking amongst yourselves, so that's perfectly fine. Let's take a look at drug follicle hair testing, because I think that might be important. I deal with these quite often, but let's just take a look at what the internet say about this. Okay. That's hair testing. I don't want that. I want hair follicle, because there is a difference between those two. But they said it was follicles, which that's the most. There we go. There we go. Hair follicle drug test is a method used to detect the presence of drugs or drug metabolites in a person's hair. The test involves collecting a sample of hair, typically from the scalp, analyzing it for signs of drug use or abuse. Here's a breakdown of the process. How it works. A small amount of hair is cut from the scalp, usually around 200 strands. The hair sample is then sent to a laboratory for analysis. The lab tests the hair for the presence of drugs or metabolites. The test can detect drug or use or abuse over a period of several months. Benefits, long-term detection. So this is what we use oftentimes. Now, in California, these are more of a situation where someone is trying to show that they are on the path forward, rather than to just do detection. And for us, we pretty much have to have an agreement to do this. For California, for admissibility, for courts being able to order it, it's only it's the least invasive possible, which is really just a urine test. Okay, you're not going to really get much of a drug test, a 10-panel test or 15-panel test, I think is what it is, through the hair follicle. But the hair follicle test will be able to see if it's in this person's, either with their nails or their hair follicle, something you can test with those to see at what point and what stage it is. And then you have, you can, I think it's up to 90 days. So you're able to see in the degree to which it is here. I don't have all the data here, but what's it, 5,000 up to 500 it says here. So it's obviously detected cocaine in the 9-year-old. Non-invasive, the test is non-invasive, does not require any needles or injections. Hair follicle drug tests are considered to be highly accurate, yes they are, as they can detect even small amounts of drug or drug metabolites in the hair. Tests can detect a wide range of drugs, including illegal substances, prescription meds, and even some over-the-counter medications. Okay, let's go back here. So that's a shocking yet important part of this whole thing. Their 9-year-old daughter had drugs. Mr. and Mrs. Rekieta each submitted to a hair follicle drug test through Minnesota Monitoring on May 30th. However, KCHHS has not received the results of those tests because subsequent to taking those tests, Mr. and Mrs. Rekieta revoked the releases of information ROI from MMI. Because the ROIs have been revoked, KCHHS has been unable to monitor the parents through additional drug testing. So the concept there, those kids have Biden follicles. Yes, it is. The kid parties harder than me. Absolutely. Damn it, Nick. Miss Sweep went to the home on May 28th. She was allowed into the home, but she was not allowed access to the parents' bedroom. So the police were just in there. I believe that was the same day. I'm not sure. Maybe that was maybe she came later. Maybe that's what Nick is talking about. The GAL is, you know what? Let's take a look. See when the search warrant was actually ordered. I think it was May 23. Yeah, they were removed on the 23rd. So okay, Nick's making a point. She went to the home on the 28th, so she comes back the next week. She was allowed into the home, but she was not allowed to the parents' bedroom. Okay, the guardian ad litem in this is in agreement that in the best interest of the children to remain in out-of-home placement at this time. Like I said, you got a guardian ad litem, that's the attorney for basically minors counsel, and if you do have minors counsel, which they have their own, that one may be a little different because it's independent. But the guardian ad litem is going to sway the way forward at this point. Not that the judge would need much, okay? And the children are in surroundings or conditions that endanger the children's health, safety, and welfare, requiring responsibility for the children's care and custody to be immediately assumed by KCHHS, contrary to welfare and best interest, children out of home. It is in the best interest, and this is the standard, it's across the nation for the most part, which is the standard of placement of children. It's called the best interest of the child. As you can imagine, that's very subjective, very. But I think we can all understand at this point, facts as they are right now. Parents test, they then refuse to have results submitted to the court or child welfare services. Then the kids are tested. Kids are positive. Drugs were found in the homes of the parents, in the parents' bedroom. Okay, so at this point, Nick made a comment that that's his bedroom. Imholt doesn't live there. He's in control of the bedroom. That's constructive possession, you will, which is, hey, the kids shouldn't be in there. So if there's a blaming that these kids are actually doing the drugs and bringing it to the house, why are they in the parents' bedroom? Okay, why are they in the parents' safe? If I found cocaine at my house, what would I do? I would flush it, like hands down. I would get rid of it. I had a client. Let's just go over this real quick. I had a client come in with his parents, and he had the little problem with some meth. He had 2 kids, and so he got his kids taken away, and he wanted to be able to, because we'll talk about this here too, to be able to see his kids. So you're like, okay, the court's always, unless you're abusing the kids or sexually abusing as such or whatever, you're going to be able to see your children, okay? But it may be supervised, and you have facility supervision, where there's a facility that takes it and you go in there and it's strangers, whatnot, or maybe you can have family, okay? So this guy wanted his parents to do it. And they're nice people, very nice people. And the opposing party is like, no, we don't want his mom to do it. So the judge wants to talk to her. So we voir dire the grandma, which is the mother. Well, it's the grandmother to the children, which is basically, she comes up there, she swears in, and then you can ask her some questions. I got her to say, have you ever found drugs at your house from your son? She said, yes. She found some tinfoil in the garage. I said, what did you do when you found that? And she said, I called the police. Think about that. That grandmother was then able to be the person to supervise the visits. Why? She was willing to call the police on her own son for protection of the grandkids. Okay, that was prior. That was something that hadn't come out. That is huge, and we did have a police report because it was all ready to go, so it was all done. That was big, and that was very important. This is something that I don't feel that Nick's necessarily doing this right now himself. Okay, let's get back to this one. So you're talking about the best welfare placement of the kids. In making this finding, the court relies upon the best interest factors considered by KCHHS as set forth in the CHIPS petition, which are incorporated herein by reference. It is in the best interest of, click, the children to remain in foster care, this is hard to read, until the parents are able to provide a safe environment documented through substantial compliance with the case plan and by correcting the conditions which have led to home placement. The placement proposed by the agency is least restrictive and most home setting that meets the needs of the children. Reasonable effects. Given the particular circumstances of the children and the family at the time of the children's removal, there were no services or efforts available to have been allowed the children safely remain in the home. KCHHS is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-home placement. However, these efforts have been hampered by the parents because the parents have revoked their ROIs, which is their ability to release their documents, have been submitted to drug testing and have not allowed KCHHS full access to the home. That's probably what Nick's saying. That's a bunch of, that's a lie. Removal date. The children were removed from the home on May 23 and it's 14 days out of home placement. The permanency progress review hearing was to be held no later than 180 days after removal, which is November 19. If applicable, the permanency petition must be filed no later than 335 days after removal, which is April 23. If applicable, to admit, deny hearing to determine the permanent status of the children shall be held by May 23. That's in a year, basically. So the permanency admit or deny hearing was held on June 6th. The parents were each represented by an attorney. The parents were advised of the right to have a trial regarding the CHIPS petition, including the right to testify or question and call witnesses. Okay, and what did they end up doing? They set this for trial. On the trial, and the require petitioner to prove CHIPS petition by clear and convincing evidence. So let's talk about that real quick. So here's a standard of proof for this, for CHIPS to be able to present what they've had here, not by beyond a reasonable doubt, but a clear and convincing evidence, which is like 70% standards or so. So it's a bit of a risk, right? But you just got to do what you got to do, I guess. After consulting with the council, parents each entered a denial, okay? Protective order. So they said, not liable for this or whatever. You're a bunch of shit. We want our kids back. And they said, okay. The parties have agreed to a protective order for discovery. The parents have agreed to waive the timing requirement that the pretrial hearing be held at least 10 days prior to the start of the trial. They waive time. So they can, it doesn't have to be a swift trial, and they'll set it as appropriate, perhaps after the criminal side, which just means you are prolonging the time that you're going to be with your kids. 5 of them, one, they just got done with school. It's summer. Great time for those kids. Best interest. It is in the best interest of the children that they remain in the protective care of KCHHS for the purpose of placement and an appropriate licensed foster care provider. Reasonable efforts. KCHHS is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-home placement. However, those efforts have been hampered by the parents because the parents have revoked their ROIs, have been... Is this what I just read? No, it's not. Just kind of reiterating it. The parents have revoked their ROIs, have not been submitting to drug testing, and have not allowed KCHHS full access to the home. Indian Welfare Act does not apply. Here's the order. The children shall remain in the protective care of KCHHS for the purposes of placement with an appropriate licensed foster care provider. I hope it's family, but it sounds like it might be foster care itself. That's just rough. Services, examinations, or evaluations. The following shall be provided to the child and the child's family pursuant to rule. I don't know what that is. Parents shall each submit to a chemical use assessment and shall follow all recommendations. Okay, we'll talk about this shortly. I want to see what the rest of it. The parents shall abstain from the use, possession of all mood-altering substances except as prescribed by a medical professional. The parents shall each submit to a chemical testing of any type at the request of KCHHS and or the guardian ad litem to verify abstinence. The parents, does that mean of their foursomes as well? The parents shall sign all necessary releases of information so that the services providers may share information with KCHHS and GAL. The parents shall sign releases of information from MMI, that's the testing services, to KCHHS and the GAL, guardian ad litem, by the way, so that KCHHS and the GAL may monitor and verify the parents' drug testing results. Okay, let's talk about that real quick, which is, remember, they got released on bond. Now, someone had made a point here, because before, Nick had paid the cash bail, and his wife hadn't, because it showed that on the docket. But someone in the comments on one of the videos said she's actually been released on bail now as well, or cash bail. I don't believe that. I believe it was just an updated situation. Well, fine. So she's out on bail as well, which means it was in Minnesota, which was an or, which is you do cash bail or you get released on your own recognizance, but you've got to do all this testing, blah, blah, blah. They didn't do that. They signed off. They paid the cash bail, so they didn't have to do that. But this is a different case, okay? This is your child protective. And the court's saying, due to this emergency situation, we are now injecting ourselves into your situation. Sorry, Nick, this is the way it goes. And with that, if you want to have possession of your kids and visit them, you're going to have to do drug testing. That's only, your child was found with cocaine, okay? You had cocaine in the house, we'll do all that. Your child was found with cocaine. Presumably, 9-year-old was not out on the street on the bad streets of Minnesota. She was getting it from the house, either accidentally or intentionally or subversively. However it was done, I doubt they were giving it to her, but she got it. Okay, that is a big problem. Your kid, 9-year-old, doing coke. I think that's a problem. I don't know. A lot of libertarians, age of consent. We got all these, debates back and forth. Can we agree that 9 is a problem for having your kid doing lines of coke? However that's done, that's a problem. Assuming that the testing is legit, and I tend to believe these tests. Okay, hair follicle tests. Much better than a lot of them else. The kids aren't trying to, I don't know what they're doing, but this is out here. Okay, so with that in mind, if Nick wants to be able to get through this and pass and go and get his kids, he's gonna have to show the court that he's clean and abstinent, and he's gonna have to do drug testing, and he's gonna have to have the released what your former, it's not, you're not gonna get in more criminal trouble. They're not gonna say, oh, tested positive. Now we're going to add on time for that. No, this is all about the family court or the juvenile dependency and the foster placement. And if you can get, we have this often in family court, which is one parent has a drug or alcohol problem. You do testing. Maybe it's alcohol. You have all kinds of SoberLink. It's a thing they blow into every so often. A random testing, they have to go to a facility or whatnot. And we start to show that it's 30, 60, 90 days. And oftentimes it's 6 months. You show me 6 months, the court's like, fine, now we're done, and you're good to go, at least for now. One of the other things they had him do was a chemical test. No, let's go up here because it was submit to chemical use assessment. Okay, we do that quite often. You have an expert that they walk them through, and they see what they're drinking, what they're Nick's online just hammering the drinks all the time. He has literally probably has a problem, or at least it's led to this. So what are you going to do? And it's kind of like what kind of plan can we put on there? But that person can also come and testify about how bad of a problem this is from a psychological, whatever kind of perspective they have, a drug alcohol professional that they do. So there you go. The parents shall sign the release. We talked about that. OHPP, I don't know what that is. KCHHS shall file an out-of-home placement plan and provide it to the parties. Foster care providers within 30 days of the court order placing the children in foster care, an order for protective care, or order transferring legal custody to KCHHS, whichever is earliest. Out-of-home placement plan shall be filed no later than June 22. Damn, that's just rough to read, thinking about that with your kids. The terms of parental and sibling visitation pending further proceedings. So I don't know where the kids are placed, if they're all in the same home. I would hope so. It's probably not possible. The kids are split up, so they're going to be able to, can the kids come visit each other, and they should be able to at least visit each other. But also, what about the parents? Visitation between the parents and the children shall be supervised at a supervised safety center or supervised at the KCHHS building by a member of the KCHH staff. So what they do is they come in there, they're able to see the kids. It's a hermetically sealed environment, so to speak, and it's monitored. So you're not able to talk to the kids about whatever. You're not able to slip them some cocaine, okay? Typically, these are situations where one parent is there and they're custody, and they drop the kid off, and then they're talking. They will monitor them. They will have a report of kind of a very 30,000 foot level of dad had the kid. He talked to him. They were talking about this. Child smiled. Dad started to say, hey, you heard I've been doing coke and diddling Imholt. And they're like, hey, Dad, you can't talk about those kind of things, okay? That's the kind of stuff they'll step in. Relative search shall exercise due diligence to identify and notify adult relatives in the family within 30 days after removal pursuant to. So they're going to try to, do family placement. It looks like at least that's part of the process. Agencies shall continue to appropriately involve relatives who have responded to the notice. The parents shall cooperate in providing sufficient information to identify relatives no later than 90 days after placement. The agency shall report to page 9. The court in effects detect regarding placement, something in Minnesota in a case. I can't read that. The order shall be shared with providers of service under the case plan, such that providers are authorized to share information with each other necessary to carry out the intent and purpose of the case plan ordered herein. So they're going to be, like I said, there's a case plan of what they want to do, and some of that is how much testing they're going. They want to get the kids reunified. That's the ultimate goal here. It should be, at least. And to get that accomplished, the parents need to follow plans, kids need to follow plans, everybody needs to follow some sort of plan. And the idea is, and I do this, like I said, all the time, not necessarily CPS, but with family law, you come away from mediation or trial or hearing, and it says sometimes if the parent's troublemaker, you've got to do, maybe it's anger management, drug testing, And so once again, let me just re-up here on the case that I talked about with the guy that the mom called him for meth. He's like, boom, he got as serious as he can do. He did everything up front, and I was having him do it even before we were going to court, drug testing and seeing the kids as much as possible. Everything he did, going to AA, whatever, trying to get treatment himself. In 6 months, he started to get more time, and within 8 months, mom got the mom had a drug problem too, okay? And she got caught on the side of the road sleeping in her car, doing drugs with one of the kids. He gets full custody, and now he's had them, and he's like he's really done well. Okay, and the parents did, but what happened was you had parents, grandparents that were more concerned about the kids than they were about him. So they were calling the cops on him, and he knew he couldn't get away with shit, and he had slipped up. And then he got his life back, and he got his shit together, and he got his kids. And it happened in a fairly short amount of time. Luckily, he had great parents and stuff, and he had a good attorney, so it worked out. And I try to emphasize those kind of things all the time. You can get your shit together, follow case plan. Sorry, Nick, the government's against you. It's probably not going to be your best interest if we have body cam footage and it's what it is, and this testing, you're not going to get around it. It's going to prolong all this stuff because you're not going to do what you need to do by the time you get into court, because you're going to be pushing saying I never did this, and then it's going to be a problem. I would suggest he does the drug testing, he does all these things he's supposed to do, releases the information, does everything that by the book he can. By the time you get to court, maybe you win that, maybe it's not so bad, or maybe even at that point you can make a deal and it's like, yeah, Nick's following the plan, he's clean, he's sober, his hair is a little greasy because he's a douche, but it's free of alcohol and or drugs. They're authorized to do the following with respect to arrange for medical care, arrange appropriate routine medical care, dental care for the kids, including necessary immunizations, vaccinate. They're going to vaccinate them from COVID. Now you got a problem. To obtain the children's educational, medical, dental, psychological, everything, including mental health, chemical dependency records, if any, in the purpose of meeting the children's health needs, and to approve educational mental health services for the children as needed pursuant to Minnesota Statute 260C.208 Subdivision 2. KCHHS is specifically authorized to have access to the following: medical data, corrections and detention, juvenile court services data, health records, providers of services to the children, including educational, mental health, the order shall, and it's almost to the end here. And then they talk about some rules of juvenile protection procedure and orders to establish the following deadlines, specific dates for procedures and hearings, the deadline for discovery. So they do a discovery deadline. We don't really care about that. A new hearing, pretrial motions, when all that stuff is due, you got to let these people know. Court settlement conference coming up. Hearing location, order subjected to revision as necessary to serve the best interests of the children, interest of justice, so long as permanency timeline are not delayed. All previous orders of the court remain in effect except as explicitly amended herein. Keith Heggleston, Judge of District Court. So there we go. Okay. Few items here to recap, which is daughter tested positive for cocaine. Nick and his wife tested, but they refused to release the information. So the court doesn't know if they were high at the time. It's going to come out. Okay. And they don't know if because there's likely their hair follicle test, like I said, it could go back 90 days or so to see. You look at the hair follicle and you can actually see, I forgot to check Rumble chat, but here we are. So we can't give our kids Coke. Thought this was America. That's conspiracy, extremist, extraordinary commenting on here. Evidently not. Not in Minnesota. Not in Minnesota. It depends. Let's say your kid's 30. My kid's 24. Not today. He's 24 in a few days, like 5 days. So once again, there's restrictions that this court can place on you if you want to be able to see your kids. That's what it is. And you want to get there, well, you're going to have to obey these things. They can have a trial and it comes out. Now, if the trial comes out and everything is a lie, then I apologize, and that sucks. It's just going to be hard to believe that, right? So you've got Nick's about a conspiracy here of a town that he's involved in, but this town has done everything to widen this conspiracy, which doesn't seem possible. Sometimes like the shortest, the simplest explanation is the best, the reasonable explanation. So what they would have to do is with this, they would then have to probably not have had body cam footage because that would crumble everything. If you say Nick's house is a mess, his wife's in there, it's not like they're not there and the police come in and find it this way where they could have planted everything. The wife was in the house. So did they find those things? And we've talked about that before. Unless you're going to see them planting it, likely it's going to be there. So that's tough to get past. And it's also going to be tough to get past this drug test. Okay. Wow, a lot of comments here I missed. Let me see if there's anything I need to find. Shannon says, growing up watching nightly news during the 80s and 90s was a better deterrent than any DARE program. Okay. What kind of person subjects their children to foster care system when they're financially stable? Okay, that's actually a very good question. Look, I'm not sure what. Let's walk this through, because Nick doesn't have a choice at this point to subject his kids to foster care. Foster care is going to be subjected on his kids due to his actions. If your question is that, he doesn't have a choice. If your comment is, why are you doing coke in the first place? I'm with you there. Okay, why would you subject your kids? Why would you put, and by the way, Hamilton, maybe go back and watch some of my previous streams on this, which is you're an adult, you have the ability to make decisions, you have 5 kids, you have all minors between, I think, like 16 to 5 or something like that. Why are you doing these things when the kids are in your care? You've fucked up immensely. And so you may not agree from a societal point of view that CPS should ever have rule over you, but they do. So therefore, maybe don't do those kind of things and be a shitty parent. Okay. The guy's a real triple threat to the courts: civil, criminal, juvenile. That's right. For someone who is so anti-government, you literally have the most valuable thing in your life to them. Yeah, that's true. That's exactly how it should be. If you fuck up, you get your shit together. Nick has shown no signs of lifestyle change yet, indicative of that. Now, he might have. I don't know what's going on in the background. I think a lot of these attorneys are saying, hey, get your shit together. Maybe that's what they're doing. Once again, why are you online? Why are you online to do it? You're not helping your situation. Because remember, he said, he goes, it's not about ego and then why are you online? Why are you online talking about it? And if you're talking about anything, you should be talking about that. So just don't go online. He did get rid of the liquor poster. He was supposed to stand up, though, and I don't think he was standing up. Seems risky to start the kid on a hard drug so young. Now it was just weed. Right, so that's where we're talking about Colt 45. Baby, that's all we need. We can go to. All right, so maybe not. Maybe not. I will go back. Happy I found your channel. Yeah, welcome aboard, people. Give me any of your feedback you need to. Explain why men want biological relief but can't take social responsibility and spiritual, financial obligations pertaining to family. I'm not sure I understand all of that, but I think it is height of being a man that your kids look up to you, you make the decisions that you're proud, and I'm trying to remember who it was, J.C. Watt, I think, he's a former congressman from Oklahoma. He says, integrity is doing the right thing when no one is around. That's exactly, can you sleep at night? Have you been doing that? That is the height to me of being a father and to being, sorry, I don't finish the sentences here because I kind of said it there, but I'll keep moving on. Graduation for my son this weekend. Very proud of him. Got a wonderful girlfriend, great family. And then I had my other 3 kids there. Very proud of them as well. Andy met them. They're nice kids. They're not out there doing shit, but they're fun. We had so many laughs. I told some jokes. My daughter's there. We're laughing. We're having a time. All the kids. And I'm very proud. You come away from a situation and you're like, yeah, we did something right. I'm also listening to this podcast right now. It's called Your Own Backyard, and it's about Kristen Smart murder, and the guy that eventually gets convicted for it, Paul Flores, complete piece of shit. His parents were a piece of shit, and it makes you wonder, how did we get here where my kids are doing well? Is it just by the luck of it, or is it a lot of the hard work that we put in? And it is. Some of it is genetics. Maybe this guy was a little freak, but his parents, he had like 7, 9 DUIs. His parents never held him responsible, so that's a problem as well. I think, did I get to the end here? Hamilton, yes, he was online last night disparaging Sweep, the investigation. Yes, I saw that. We played a bit of that. It was pretty troublesome. Shannon gives the hands up. Exactly where there's never the wrong time to do the right thing, even if no one is watching. Yep, exactly. All right, people. I think that's what I got. Did I have any other? I had some other links here. Stuff to hair follicle tests. I mean, those are hard to get around. McKenna's Law, we talked about that. Hair testing, that's a little bit different from that. CHIPS is basically Child Protective Services in Minnesota. I think we got everything we needed there. So Sorry, I bumped Nick and he started talking. There we go. I think that's where we'll end for tonight. Thank you, everybody, for joining in. There we go. We're going to play some Total Eclipse of the Heart as we exit here. I'm going to do another show probably on Friday. So like the show, obviously, subscribe to it, turn the notifications on so you can get that. Because on Friday, I'm going to talk a little bit more about college. My son, like I said, went to college or graduated, and some of the disturbing stuff that happened. A few other news stories along the way. But as always, we'll keep up on the news of the day with trending legal cases. All right, everybody. Till next time. See ya. Oh, tonight, Tower Gang.
Okay, I'm leaving now. Bye, guys.
But she's back.
And now.
Chick-fil-A is completely overrated. It's not that good. I prefer Zaxby's. I prefer Popeyes.
Takes a tough man to make a tender forecast, Nick. And I guess that's me. Keep fucking that chicken.
Should I vote for Dick Cheney on the Libertarian Party? Do I have an obligation to vote for Dick Cheney?
I would say so.
Yes.
Did it work for those people?
No, it never does. I mean, these people somehow delude themselves into thinking it might, but it might work for us.
That one dude was like, not a podcast, I can't find it anywhere, and they don't have video.
Oh, yeah, Peter Janke, yeah.
Yeah, I blocked him.
I'll do it. If he unblocks me,
He'll buy your shirt if you unblock him, Bert.
He's a wigger.
Yeah, nothing cooler than a 49-year-old wigger.
Like, I just started live streaming. Cut me some slack. I'm pretty high tech for a boomer. But anyways,
boomer.